The Commonwealth has charged Karen Read with second-degree homicide for hitting her boyfriend, John O'Keefe, with her car. They've also charged that she did that while under the influence and that she left the scene. The defense is arguing that Karen Read was framed, that this was all a cover-up, and that she did not hit John O'Keefe with her car. Something else happened to him that evening. Before the break, on the morning of day 12 of the Commonwealth versus Karen Read, we finished up the testimony that we were ending with yesterday, which was the testimony of witness 31, Julie Nagel, finished up redirect. And that was about it. Again, on recross, the point was made that when Julie Nagel put two and two together, that what she thought she saw on the lawn was potentially a body, she did nothing with that information. But the prosecutor set that question up in his redirect, saying, if you thought you had seen a body on the lawn, would you have called 911? She's like, yes, I would have called the police, which tees up the defense to come back in and say, hey, when you realize the next day, when you, as you said in your words, put two and two together, who did you tell? Did you call the police? Did you let them know what you had seen? Did you say you need to interview me? I saw something. No, you did nothing with that information. Interesting. Then we got into a witness out of order. The witness out of order is Terry Kuhn. She works at UC Davis, which is a really quite prominent veterinary school that has a forensic lab that she helped set up. She tested the DNA swabs from a shirt. We don't have any more information in evidence yet. She tested the DNA swabs that were taken from a shirt from the Massachusetts State Crime Lab and found that that shirt did not contain any canine DNA, but it did contain pig DNA. And we heard a lot of reasons from the defense why that could have happened, but the defense used that prosecution's witness to allow and to explore the testimony of what are crime lab procedures. You don't know where they swabbed. You don't know how they swabbed. You don't know how it was preserved. You don't know what they did. You don't know if they were swabbing the right place on the shirt. Wouldn't it be ideal if you're swabbing a shirt to mark on the shirt where it was swabbed? Doesn't it make sense to do these things? And went through those procedures and then got into the procedures for storing blood evidence. You wouldn't preserve blood evidence in plastic. And why not? Well, because there's room for contamination, mold growth, and other types of growth when it's kept in plastic. And then he said, so you wouldn't store it in a Solo cup. And the witness said, I'm sorry, what? And then there was an objection and it was sustained. But the I'm sorry, what speaks for itself. And it's clear that this witness was caught off guard by the Solo cup question, as we all were, by the Solo cups at issue here. And at the very end of that witness testimony, the defense, and they've done this time to time, pushed too hard, I think. And the defense pushed quite hard at the end by plowing through a question that I think that they knew they probably shouldn't ask this witness, did anyway, which was, did you know that the person who swabbed or took these swabs had failed their proficiency? And that was immediately objected to. The objection was sustained. The judge struck it. The person who swabbed this has to come in, or all of that evidence is going to be thrown out. And they are going to have to confront that witness who swabbed things about whether or not they passed their proficiency exams, failed proficiency exams, when in time that was. Was that after this testing was done, before this testing was done? And so all of that will have to come in with this witness that did the swab. There are times when the defense pushes too hard, and if the jury's not 100% on board with them, that can turn the jury off when it is too much of a reach, which confuses me at times in this case, because there are things you don't need to reach for in this case at all. Like, this defense team is not grasping at straws. Isn't it really weird that two people just got rid of their cell phones? Isn't that suspicious? Isn't it really weird that stuff was collected, I don't know, in red Solo cups, that people weren't interviewed separately? Like, there's so many things in this case that reaching for some of the things that seem like a stretch maybe isn't necessary. So we will see how that goes. And then as you get to the last witness of the morning, witness 33, Ryan Nagel. Ryan Nagel is the brother of Julie Nagel. He came across to me quite credible. He saw what he saw. He was out with his friends. They went to pick his sister up. She's like, I'm going to stay longer. But he saw the SUV parked in front of 34 Fairview, the dark SUV. He didn't notice any damage. And again, one would have to think that if the taillight was that broken and the red pieces of plastic weren't on the taillight, then it would be taillight red and then white reflecting on the snow. He said he noticed the taillights and the third taillight. He said that he saw the SUV closer to the mailbox and then pull forward more towards the flagpole. And that as they were leaving, he saw a female sitting in the driver's seat with long hair, and he didn't see anyone else in the vehicle, and the dome light was on. And he said the driver was at 10 and 2. That's what he saw. Can we connect the person he saw in that vehicle to being the defendant? Not at this point. But he said there's nobody else in that SUV at this point in time, which is sometime after midnight. I don't think they have all those text messages when he's telling his sister that he's here. Otherwise, I would have thought that we would see those to kind of pin down in time when he was texting his sister. Maybe if law enforcement had interviewed him earlier and asked, can we see when you were texting your sister to get the time? He would have said, yes, this is when I was texting my sister, and law enforcement would have had those texts. But right now, it seems the only person who has those texts is the one who asked for screenshots of them, Jen McCabe. We are at the lunch break at the morning of day 12 of the Commonwealth versus Karen Read, and we are finally starting to hear from witnesses who say that they saw people inside the black SUV or a black SUV parked outside of 34 Fairview sometime after midnight. We heard from Ricky, who was driving the Ford F-150, that Ryan Nagel and his ex-girlfriend were in when they went to go pick up Julie at 34 Fairview before she said, no, I'm going to stay here a bit longer, and then went back inside. So we have heard from some witnesses that they saw the SUV go from where it was at the mailbox and move further down Fairview towards the flagpole. We heard from some witnesses that say they didn't see the SUV move at all, but we heard from multiple witnesses that as the Ford F-150 was pulling away from 34 Fairview after Julie decided not to leave with them and they decided not to go inside the home, that the passenger compartment light was on in the black SUV and that they saw a woman in the driver's seat. One witness said she also saw a man with short hair. No one mentioned a hat, and a woman with long hair. No one identified that as Karen Read, but the defense on cross-examination asked, you now know that that was Karen Read in the SUV. So the defense is not contending at any point that that black SUV is not Karen Read's SUV and that that was not Karen Read driving the SUV. The state hadn't elicited that. I'm surprised the defense asked it. But again, the defense theory of the case is that Karen dropped off John O'Keefe and left. So they're not contesting that she was there. And I'm sure her cell phone data will place her there at that time if we ever get to those witnesses in this trial. We'll see if we do. I was just surprised they asked it at cross-examination. But at cross-examination, they're like, we now know that that's Karen Read in the car, right? Like, you now know that. And I was like, oh, okay, well. That's surprising, but there they go. This is Karen Read's SUV, and this is Karen Read in the SUV. Interesting. We will see where this goes after lunch. We are now on the witness who picked up Colin Albert from 34 Fairview, not his cousin, but a lifelong friend. And that is Allison McCabe, Jen McCabe's daughter. And why I say not his cousin is because the McCabe side of the family is only related to part of the Albert family because Jen McCabe is sisters with Nicole Albert, married to Brian Albert Sr., who lives at 34 Fairview. Colin's father, Chris Albert, is brothers with Brian Albert. So they are not related by blood, but everyone in this town is somewhat connected. Not true. Everyone that's testified in this case is somewhat connected because everybody was at the house. So they are just adjacent. And Brian Albert Jr. made it very clear that the McCabe's are not Alberts, so they are not in the cousin Snapchat with all of the Albert cousins. We are at the end of day 12 of the Commonwealth versus Karen Read. And though it has been a full day, at the end of the day, we finished testimony from Allison McCabe, who picked up Colin Albert from 34 Fairview, and then began the testimony of Colin Albert. Both of them have now introduced text messages between the two of them from the night of January 28th, between the two of them, showing arrangements for Allie to go and pick up Colin at 34 Fairview and saying, like, here, okay, around 12:10 a.m. Where we are, watching those get put up on the screen in court and then zoomed in on with the camera, the texts don't look like they have a bubble around them. They said in court that they do. We haven't seen, of course, the paper copies of those. The jury will get to decide what weight to give those text messages and if they believe that they are true. But there is also no date when it clicks over from like 11:55, 11:57 into 12:10 a.m. There's no new dateline, which also looks odd. Then there were no texts at all between January 28th, 29th, and like February, where she says on Zoom. Yeah, there's a giant gap in those text messages, which is really interesting, but nobody asked her for them. And her phone was never downloaded or extracted or shown because it doesn't seem it was actually investigated. I don't know what I think of the text messages yet. We haven't even gotten into forensics. What we do know is that law enforcement never really asked. In the testimony of Allie McCabe, the court found that the defense had opened the door for her to talk about some of the harassment she has received. I know that they approached this in motions in limine, and both parties had agreed. These were the only motions in limine I watched because I thought it was so odd that both parties agreed, and then the judge was like, no, I don't agree. Both parties had agreed that they were not going to ask witnesses about harassment, witness intimidation, and things like that. But the judge said, I'm not going to tie these witnesses' hands. If the doors are open, then it can be asked about. Allison had given an odd answer when she was asked why she hadn't turned over text messages sooner. And the defense pressed her really hard. Well, you never turned this over. And she said, well, it wasn't relevant. Colin had not been introduced as being in the house at that time. So it seemed that she knew what other people were saying, knew that other people hadn't told anyone that Colin had been there. And then she said it wasn't relevant because Colin wasn't there when John was there. So the jury's going to take away what they will from that. Does that mean when John was in the car with the defendant out front at after 12:30 in the morning? Does that mean that she believes that John was in the house? The jury gets to decide what, if anything, yes, I did that on purpose, that sentence means. But she said when John was there. So the court allowed her to explain why she didn't think it was relevant and why she was explaining that, and let her get into the harassment. She said she and her bestie, though not cousin, Colin, had been suffering. The court limited it and said, no, this not as to Colin, as to this witness. And she talked about it briefly and took a break as she got emotional in talking about that. And then that was very quickly the end. The defense didn't press her more on that. And that was the end of her testimony before we got into Colin Albert's testimony and those text messages and when he went home or when he didn't. He said he was driven directly home, but he also said he doesn't remember what side of the car he got into when he came out. He said he came out the side door, not the front door. Others testified, including Nicole and Brian Albert, that they saw Colin leaving their home as they were coming in through the front door. So are those natural discrepancies in memories because everyone had been drinking? Or is it more than that? I don't know yet. So as we continue to get into this case, again, more questions than answers still on day 12. Eventually, we're going to have to get into some tech witnesses to talk about what these phones are doing, because we got into a little bit of Allie McCabe's Life 360 and where she was driving to and from and where, about, and when, and that she arrived home at 1:30 a.m. So did she arrive home at 1:30 a.m. or did she arrive home at 12:30 a.m.? Because that would change when she drops off Colin Albert, or could change when she dropped off Colin Albert substantially. So I hope we get more into that, because I've got a lot of questions about it, and I bet you do too. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I